Okay, everybody, what we have in store here is just a quick update. This is not going to be a full panel segment, but when I found out that Tobias was going to join us here, I asked him if he could give us an update on the UPC. So Tobias Wuttke is a partner and attorney at law at Bardehle Pagenberg in Germany. And I probably didn't pronounce that right. I keep trying. I'll get closer, my friend. Bardehle Pagenberg. So Tobias is at Bardehle Pagenberg in Germany, and he and his firm have 20% of the cases that are currently before the UPC. So he is really an expert on the UPC and is representing an awful lot of companies and patent owners. So when it became clear that he was going to be able to join us and make it here, it sort of happened a little bit last minute, but I wanted to fit in at least an update on where we stand in the UPC. So Tobias, I'll throw it over to you. And what I'll also tell you, the audience, is if you have any questions, Tobias is happy to answer any questions that you have. So, but Tobias, great to see you. Thank you for coming. And I'll kick it over to you to start your update. And then if you see questions, you can just recognize people from the stage. Go ahead.
Thank you, Gene, for the kind introduction. It's a great pleasure and honor to be here and speak to you. Why is this new European patent system relevant for you? It's called the Unified Patent Court, but you could also call it the US Patent Court. Why that notion? Because most users of this new system are US companies, both from the plaintiff's perspective, but also as defendants. So it is relevant for you. And this new Unified Patent Court basically has jurisdiction over US companies. And that means it has a huge importance for risk management. Patent litigation is risk management, and this new court can issue an injunction for 18 EU states. And so this injunction would cover almost as many people as in the United States an injunction would cover. But apart from the ITC, in most cases, you don't have injunctions, and that's the reason why US companies are turning to the new Unified Patent Court. Again, a little bit of general background. We have this system since June 1st, 2023. And so we are now 17 months into the UPC, this new court. This new European system has two pillars. Pillar one is the new Unified Patent Court. Pillar two, the new unitary patent. So one single right covering 18 EU states, one-stop shop. And the uptake rate as of today is 25% for this unitary patent. And guess what? Which company is the most frequent user of this new unitary patent? It's J&J, a US company. Number 4, Qualcomm, US company. So you see it's relevant for the US patent community. And so the Unified Patent Court, where does this name come from? It comes from its competence. It's competent per se for the new unitary patents and also for the traditional European bundle patents that you know, where we have out there more than 1.5 million. And only if you say, I want to preserve the status quo, then you do this opt-out. But the opt-out only applies to the bundle patents. And we have 600,000 opt-outs above, around that figure. But the opt-out rate is going down. For the newly granted European bundle patents, we are close now to 40% and below. And what does this mean? We have this transitional period of 7 years, and only in these first 7 years you can do the opt-out. After these 7 years are over, the new Unified Patent Court is the reality for both the unitary patents and the traditional EP bundle patents. And the 7 years, 20% already lapsed. What does this mean? There is no sit and wait approach. And if we now look at the industry we are discussing today, what is the pharma and life science industry doing? And you could say it's a fair analysis. They are testing the system. What type of cases do we see? So we have Amgen versus Sanofi, you know that from the US. It's an antibody originator case. Sanofi versus Amgen, also second medical use antibody originator case. Alexion Amgen, biosimilar. Sanofi versus generic companies, small molecules. We have Novartis Celltrion. It's also a biosimilar case. And we have a lot of life sciences cases going on. 10x nanostring, 10x Visgen, 10x versus Curio. So the industry is making use of the system, testing the system. And that means it's not staying away. The UPC is a startup. It was created 1.5 years ago, and it has still some teething problems. You have heard about this infamous case management system. It's an electronic case management system, but it's very cumbersome, and it will be replaced by June 1st next year. And then we turn back to the EPO-style e-docket system, which is very convenient to use. And what is the other teething problem? We have part-time judges. The current judges, the lion's share, have 2 jobs. They are still in the national system, and on top of that, they are UPC judges. 2 jobs, wow. That sounds stressful. It is stressful for them, and they work on weekends. And we all know if that continues this way, the quality will go down. So there is at least we as attorneys do everything we can to convince the policymakers to upgrade these part-time judges to full-time UPC judges. And why is this relevant? Because the UPC is a success story. Now I tell you the numbers. We have 190 infringement cases, so that's 10 cases per month. You could say these are low figures. This is disappointing. But on the other hand, these are high-profile cases. I named the companies fighting before that court. And still the most frequent user of this new court is a Japanese company, Panasonic. So you see really the global players are coming. It's maybe a court for the big boys. And so why? Because the power of the injunctive relief is simply enormous. We have seen trends in the SAP world where companies injuncted in Germany simply left the German market. Yeah, Lenovo is one of these examples. But you cannot leave 18 EU states. It's impossible. You cannot do this as a company, as a global player. And so 10 cases per month, that's the average growth rate. And yeah, you see there is no spike. It's continuously rising. And I think that shows the trust, but also the reservation to a certain extent. It's not all in, yeah? And I come to the reasons. What is important to you, the infringement cases are heard before the so-called local divisions. That's a typical European compromise. The court of first instance is spread out across Europe. We have 13 local divisions, 4 in Germany, and they have 80% of all cases. Why is this? Predictability. Because in Germany, the Netherlands, Italy, and France, you have on the panels 2 national judges and 1 international judge. And you can do the math, 2 versus 1, and the presiding judge is a German national. So in the end, you get to a certain extent, and that holds true for the infringement cases, you get German infringement case law at the UPC. That's the executive summary. What we've seen so far is German infringement case law. What is missing? File wrapper estoppel and doctrine of equivalence. We have not received case law on these 2 questions. The Court of Appeal shied away on file wrapper estoppel. They had the chance to comment on it, but didn't do it because it's a controversial matter. So they shied away. What are the main features? We have full forum shopping, no TC heartland. You can go to all of these 13 local divisions, but 80% of the users go to Germany. The proceedings are super front-loaded, and that's relevant for global campaigns. The UPC rules of procedure require the plaintiffs to provide claim construction early on. And if you have a US case in parallel and no Markman hearing was there yet, you will hate to provide claim construction early on if there's a global campaign. Yeah? Front-loaded all facts as early as possible. We see super tough case law on late filing. We get preliminary injunctions at the UPC, and 20% of all cases are PI cases. That's very important. So PIs are really sought at the UPC, and the UPC grants interim relief. Yeah, that's very important. Most important, without the need to provide a bond. If you are good for the money, you can enforce the PI on the moment it's handed down and uploaded in the CMS. That's super powerful. 18 states, you get a prohibition for the market, one in the logical moment after it's in the CMS. Wow, 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 wow. That's a powerful tool for the startup. And the injunctions we've seen so far were automatic injunctions. It's unclear whether we see any kind of eBay watering down of injunctive relief. So far, not. It's a one-stop shop for damages. That's the big difference now to the old system, where you won in Germany and then the defendant said, yeah, I know your EP patent is also valid in 7 other states, but I will not give you anything for that. Sue me there. Let's fight there. And that costs you so much money, we better settle now, and you give me a huge discount that I'm willing to settle now. These days are over. It's a one-stop shop for damages for 18 countries if we talk about the unitary patent, and up to 18 if you have validated, like the pharma industry in most cases, in all these 18 countries. Now, the water into the UPC wine. Why should you shy away after all I told you? Automatic injunction, forum shopping. There is a new central attack. Yeah, the UPC is, like the US system, a system where you have a counterclaim for invalidity. In addition thereto, you have even a standalone invalidity action. And this is in addition to the European Patent Office opposition procedures. They run in parallel. And also here, the system is one bullet kills the patent. Yeah? So if you have, of course, a crown jewel as a pharma industry company, you better think twice whether you risk it at the UPC, because the invalidity attack will come. The case law we've seen so far, it is similar to EPO case law, and the problem is the handling of auxiliary requests. These are the fallback positions when you say, okay, claim 1 is granted, that's a little bit too broad, yeah? I have to narrow down. And here the UPC basically says you need to present a reasonable number of auxiliary requests, less than 10. That's what current case law suggests. That's not a lot, in particular if you have different line of attacks. And you need to bring them as early as possible. That means with your first chance. If you want to bring them later, you need a very good reason. And for the time being, in most cases, these reasons were discarded as not convincing. And for a patentee, if your fallback positions are kind of made complicated, that puts you in a difficult spot, because the lion's share of all cases, you win in Europe on an amended claim set. That you enforce your patent as granted. This is in less than 20% of the cases the reality. What are hot topics? So 3 more minutes. Transparency, it's a big topic because most US users complain we cannot get access to the file. That's true, but you get access to all decision and orders, but not to the briefs. Yeah? On the other hand, is it so different to the US where all relevant portions of the briefs are under the protective order anyway? I don't see that as so problematic. We have now recent case law, you don't get discovery at the UPC. We have Rule 191, which would allow for that, but it was now construed in a very narrow manner. That means we need 1782 in addition to the UPC procedures. Again, Friend, everyone is waiting for the UPC Friend decision, but this was called off in the Panasonic case because we had the developments in the UK, so there's a big fight between the UK court and the UPC is who will set a global friend rate. Will the UPC do it? We don't know. And yeah, so all in all, I would say for me as a practitioner, it's fantastic. It's a really new system. It's a super challenging situation. We are uncharted territory everywhere. A lot of fun. And yeah, so the quality of the decisions is good, and I'm happy with the system, to be clear, and the judges want to make it a success.
Good, good. I have a question before I see if anybody in the audience has one. When we last spoke here, you mentioned that at that time, Panasonic, I think, was the biggest user of
Yeah.
the system. Are they still a large user of the system?
Yes, their case just settled last week, so but still they had a big case, at least one of the cases settled, yeah.
Yeah, because that's eye-opening, I think, because the Japanese companies are not known to be particularly litigious, and yet they were one of the first and heavy users of the system. So they obviously have some confidence.
Absolutely, and other Japanese companies joined the crowd. So when you look at the users, the plaintiffs, we have basically from every territory in the world, US, Korea, China, Japan, Germany, from all relevant countries, we see users making use of the system. So there is confidence on a global level in the system.
Great, great. Does anybody have any questions for Tobias? Steve?
Can a party bring an invalidity action other than as a counterclaim? In other words, can a party initiate an invalidity
Yes,
action?
we have a standalone invalidity action, and you can bring it. What you can't do, you can't do it as a straw man. Yeah, very likely we don't have straw man practice like at the European Patent Office. You can bring an opposition without kind of making clear who you are. You can file it under the straw man limited. Yeah, but at the Unified Patent Court, you need to show that you have an interest to invalidate the patent, and that means in the end you need to explain why you are there and who you are. That also applies actually to this transparency issue, request for file inspection. You need to explain why you want to get access to the file. And that means no strawman requests in the end.
Can you clarify what kind of reasons one would need in order to be able to file an invalidation action?
Oh yeah, basically any reason that you are, but just not hiding who you are. So it's a very low threshold. The basis is the French system and the Italian system who don't know strawman actions.
Have there been any interesting decisions in the life sciences area and any interesting injunctions you can talk about?
I mean, so I have to be careful because I was involved in these cases, and they are still pending. I mean, the first PI on a unitary patent was in the life sciences area. So, and that PI was lifted by the Court of Appeal, and for claim construction and then obviousness reasons, and we've seen other PIs in the life sciences field.
Dan?
Have you seen any situations in which statements of non-infringement have been filed and been used to anyone's benefit?
What do you mean by statements of non-infringement? Amicus curiae letters, or
What was that?
like amicus curiae letters, or what is it?
I understood that it was possible to file, I believe, with the UPC a statement of non-infringement that's just sort of kept on file.
Yeah, that's what we call a protective letter, so an anticipatory defense letter that if you kind of fear that a preliminary injunction will be filed, you present your arguments early on. And we have seen basically in most PI cases they were on file. And now the question is how relevant were they? You would need to study the whole docket to see basically whether they were successful or not. We have one case where the UPC mentioned that this protective letter was so weak that they even thought, okay, that made the case for the plaintiff because the arguments were so weak, and then they were prepared to issue the PI. This was the Maestroma case. So you have to be careful. Don't put on file a weak protective letter because this could even invite the UPC to issue the preliminary injunction.
Steve?
If a party initiates an invalidity action in the UPC, is the burden of proof the same or different as compared to an opposition, conventional EP opposition?
Burden of proof is on the claimant, yeah, and needs to prove invalidity. Full burden of proof on the claimant, on the invalidity claimant, yeah.
Okay, any final words before we let you go?
Stay tuned. It's really a developing story and system, and closing the eyes is not an option.
Great, great, awesome. Thank you very much, Tobias.
Thank you very much.